Welcome to the Third Side podcast with myself, Sheena Jonker of ADR Network SA, and Advocate Ian Dutton of the South African Medical Legal Reports. Ian, over to you to introduce our guest.
Thanks, Sheena. Yeah, very pleased and to have with us Conrad van der Vyver today, a guy that I'm starting to get to know fairly well through various dealings to do with personal injury matters in the main. And a very pleasant guy and a very knowledgeable guy, and a guy who's been very much at the center of these developments around mediation over the last year or so. And Conrad, really looking forward to hearing your insights. Conrad is a very seasoned personal injury attorney with a very busy practice. He is also the executive committee for the RAF for both the Gauteng Attorneys Association and the Pretoria Attorneys Association. So he's the right guy to talk to us from the coalface as to how attorneys are seeing it. And let's get into some of the real issues around mediation from a practical point of view. So welcome, Conrad.
Thank you. Thank you, Advocate Dutton, and thank you, Sheena, for having me on. And we hope that we can have a good podcast for the listeners.
Yeah, thanks very much. Conrad, please call me Ian. But thank you for that. Conrad, yeah, you know, the thing is that I think what we're really looking for this evening is to have an open discussion. Let's hear different perspectives. There are no absolute answers. The answers are not cast in stone, very far from it. I think there are some common objectives, which you could say the judiciary and the various role players, I think, probably would share as far as a desired bigger picture outcome. But what seems to be emerging that a lot of the devil here is in the detail. And how do we get to an acceptable solution in this country to a major challenge to our civil procedure and getting access to the courts? And then on a little bit, zooming in a little bit on that with particular reference to mediation and some of the particular challenges that mediation presents. So I think maybe with that introduction, can I just ask you, just give us a bit of an introductory position as to, you know, how are you experiencing this protocol? How is it impacting on practice in particular, and what are your overall thoughts on where we are and where we're going?
Thank you. Well, firstly, we have to start off what was the goal, and the goal was for a massive problem that occurred in our courts, especially in Gauteng, where trial dates had a lead time of 2051 at the time of the practice directive, but it was at the time where it was indeed signed into by then the judge president, it was in 2052. So you're looking at a lead time of 7 years. So of course something drastic had to be done from the judiciary perspective in order to have lead times not be 7 years before you are actually in a court in order to have your matters ventilated. So starting from that backdrop, one can definitely see the view from the judiciary of why this was done. There was a committee that was established in which parties was involved where the directive was deliberated. There were parties, there were counsels, there were mediators. There were the judges that acted as chairs of the council, where everything was ventilated, or a lot of the issues was ventilated. However, the practice directive came out with certain controversial aspects. The first one of saying being that the Rule 41, which indicates that mediation is voluntary of nature, it now changed to a mandatory mediation. And coupled with that was the automatic removal of civil trials that has already been set down from a RAF perspective, the second semester of 2025, and then from 2026 onwards, all matters has been removed from the roll, and that you need to follow the mandatory mediation process in order to apply for a trial date after you have obtained a mediation certificate. So I believe that that is the first and foremost outcry that is that came to the forefront by the attorneys and by other individuals of South Africa. Because now one has to remember, is just because your trial date was, let's say, set down in the latter part of 2025 or 2026, it didn't mean that you got that trial date last year. It meant that you got that trial date years and years ago, and you've been now waiting for this trial date for years for your matter to be ventilated in court. And now suddenly it has just on a drop of a dime been ripped away, and there's new hurdles that you need to jump over in order to retain that trial date in 2025 and 2026, or completely lose it and have to reapply for say. So I believe that that was one of the biggest contentious points that the profession has a gripe with at this stage. So practically speaking, if one has to look at what the process is to follow, in the event that you have a party that doesn't want to play ball with your amplified Rule 41 notice, as you would call it now, at that stage, you need to jump through a new hurdle in order to launch a special interlocutory court application. And only after then that you have declared them a delinquent, then you can only be excused from mediation. So, of course, there's an automatic cost implication if one has parties that is not willing to go into mediation. So that is one of the practical issues that one needs to deal with, and one needs to deal with first. So from that perspective, and I can maybe give it over to you now, Ian or Sheena, to say how you guys see it from the voluntariness to the mandatory perspective in which the mediation directive in Gauteng has been brought about.
Okay, so I'll give you an answer, and then I'll ask Sheena to comment on this as well. I think the first point to make is this: a question of voluntariness / mandatoriness is something that has attracted a lot of attention, both within the mediation community and then obviously from the, as you pointed out, from the legal practitioners as well. It is not something that is widespread internationally. I'm not an expert on international mediation and those initiatives, but I know, for instance, the UK position quite well. There's some very well-known cases. A case, Halsey's case, where senior courts in the UK point out that alternative dispute resolution should in fact not be mandatory. The thinking being that if you're going to go to alternative dispute resolution, to me, I think the strongest point really is, if it's non-voluntary, how do you expect to find an agreement? So the traditional mediation thinking is that what compels people to mediation and why they go to the table and why they stay at the table is because it's in their interests to go to the table and stay at the table. And it is their interests that keep them at the table, not the rights attendant on like a sort of a legal paradigm. It's what they want from the outcome of those negotiations. So that, I think, is one important point. I must say something that I haven't heard very much currency about, but I must say that where I have some sympathy for the thinking behind mandatory mediation, and I must be honest, because as I see it, is that if we look at Rule 41A, to me, it was so disappointing the way that it was not taken up by the legal profession and was not enforced by the judiciary. Because, I mean, I'm hearing a lot of people saying now that the concept of mediation is a very good concept and it can work. I know that. But it has not been taken up by the profession. It has not been enforced by the judiciary. And to me, there are big questions about why is that not the case? Is that a lack of education? Is that a self-interest and a sort of dog in the manger approach? We're not even going to look at mediation. What is it? But from a systemic point of view, there is a problem, because here's a potential solution which has not been taken up for whatever reason strongly enough. And to that extent, I have sympathy for the position that well, then let's just make it mandatory. Whether that ultimately is going to be practically a solution, or whether it's just going to cause more problems, as you've said, the reaction from the legal profession in itself now is almost alienates the legal profession from that particular initiative. And what you actually want is the opposite. You want the legal profession to embrace mediation, and yet we have a very strong now antagonism towards mediation. The last point that I will make on this, which I find maybe with a little bit when the dust is settled, people might think this through a bit more, is there is definitely a scenario in terms of which mediation presents a solution which benefits all parties. In other words, you get shortened lead times, which you quite correctly raise. That certainly is inherent within the mediation model. And I think attorneys and advocates could adapt their practices to quicker turnover of matters. I understand the economic imperative, but actually a mediation is a full day's attendance. It's just as thorough a preparation. You have to understand your expert evidence. You have to understand your expert reports. There's a full preparation for trial. And really, from an advocate's point of view, I can tell you my charge out rate, whether I go to mediation to a high court trial, there's not really much difference. So I come from that very simple perspective from a financial point of view. Those are sort of my main points that I would make. And I think, Sheena, you can jump in here. And now listen, Sheena's a far more experienced general mediator than what I am, or she's one of the most experienced mediators in the country. So it'd be very interesting to hear what her take is on that.
Yeah, so my take is that in an ideal world, mediation is voluntary. Mediation is something that people choose. But I think it comes from shifting something in society from less adversarial ways to from the more adversarial and litigious ways to less adversarial ways and more cooperative ways. So I do think it is it is a challenging environment to mediate in when people are forced to the table. And one does encounter some hostility. But having said that, we're also seeing a lot of the, and I think Judge Davis actually said this in his talk to us in Johannesburg, a lot of the kind of unintended spin-offs of this directive is that we're seeing a lot of law firms reaching out to us. So we're an RMO, ADR Network SA is one of the RMOs, and we're seeing a lot of law firms from other provinces reaching out to us, asking us about mediation, even coming to mediation, even resolving their matters at mediation. We're also seeing that in Gauteng, at the very early stages of litigation, the letter of demand, the very early stages of the pleadings and that kind of thing, even before the parties would necessarily, well, I suppose that would just be letter of demand stage, but before they'd be engaging with Rule 41A, they are seeking out and asking about mediation and oftentimes even coming to mediation. So I think there is consensus building going on. So in as much as there is, we do encounter the resistance, and we do encounter the parties that are kind of feeling, well, let's just let's get this behind us. This is not going to be possible to mediate, etc., etc. There's also a lot of other stuff happening around where I think the mediation discussion is being highlighted. And so a lot more people are saying, well, let's just, let's try this, let's see how far we get. And oftentimes it's working. I did ask Conrad when I first reached out to him after the discussion with you, Ian, I asked him, and maybe he can just comment on this, that there's been this latest amendment to the directive that makes provision for not going to mediation if the parties agree that it's not appropriate, or if one party wants to argue that it's not appropriate. And I asked Conrad whether it changes the impact on those who feel resistant to mediation at all. And Conrad, do you just want to maybe comment on that?
Yes, no, definitely. Well, the latest amendment of the directive, which I could understand, and I attended an annual general meeting in which the Honourable Davis indicated that the reason for it was that there is true disputes that can never be mediated. And they acknowledge that. However, what you then now need to do is you need to proceed by ways of a joint minute and then place it on a opposed motion roll by ways of a stated case. So if there's, let's say in a road accident fund perspective, a merits dispute in which the road accident fund is of the view that the plaintiff, who is possibly at this stage a driver, was the sole cause of the collision. That is not something that can be ventilated by ways of a stated case, as you need to lead evidence in that fact, and you need to have cross-examination on that as well. So that brings you to a tad bit of a wall that you then run into, because now you need to proceed on a stated case, but not every single case is made out to be or have the opportunity to proceed by ways of a stated case. There is some opportunity for where a stated case can be made out. However, now we are sitting again, and this is my view, we are supplementing the backlog of one role for the backlog of a different role. We most definitely had a backlog by the trial role. However, now there are thousands of special interlocutory court applications outstanding that needs to be placed on the roll, of which applications need to be brought. So one needs to have a practicality view of this, is that aren't we just supplementing one backlog of a role, which was the civil trial role, and now placing burden on other roles, such as now the opposed motion role or the SIC role, or this newly found special default judgment role, which in my view is a contentious point on its very own, because how can you be on a default judgment role but the defense of the defendant is still intact, because the protocol only indicates that you can only proceed to strike their defense on the day of the special default judgment? So that's a little bit of a strange phenomenon, because if we look at the rules of court, there's a very, very different rules of court that you need to follow by ways of a default judgment or by ways of a civil trial. So which part of the rules do you now need to utilize in order to place a proper case in front of a judge, because all practitioners still need to stay within the uniform rules of court in order to set up their case and in order to have same adjudicated. So that's a little bit of a tad difficulty, again, from a practical perspective. From a theoretical perspective, I can definitely hear what you and what Ian has to say, in that you are already seeing a type of a spin-off in which individuals are taking the chance of proceeding with mediation, which is fantastic. And I agree with Ian in the sense that Rule 41 was used as a checkbox process before this mandatory mediation, because there was a lot of Rule 41s that went out. And I can say this from my own practice, I have, before this mandatory mediation directive, never received one reply to a Rule 41, in which is emphasized in terms of Rule 41A, 1-2.
Yeah.
So yes, definitely it has sparked a massive thing, which I think from a theoretical perspective is great. I think mediation in its theoretical form is absolutely fantastic. But then again, one needs to sit back and say, okay, from a practical perspective, how are we going to make this work? Once again, taking the road accident fund in terms of that, and I think maybe we can work into that practicality a little bit later. I wanna see what Ian has to say from that, what I just said now. But there is a massive practicality perspective that I definitely do want to shed light on, because I don't think that the greater part of the population of South Africa actually understands the process that needs to be followed and what gears needs to work in the background in order for mediation to be successful.
Yeah. No, Conrad, I totally, there's some very important points there. really, I think the one that I'd like to, there's a lot of points, but the one that I'd like to pick up on, which is coming through, is a little bit of a theme of what we're talking about, and let's hope that this is an accurate reflection, is that there is now meaningful debate and increased understanding of mediation, and I would say even more broadly alternative dispute resolution, but let's focus on mediation. Mediation as a viable tool in the toolbox of a responsible and competent and properly functioning attorney and advocate in this country. So,
Yeah.
so that's the first point. And I think that just the fact that we are now having this type of debate, I think, is probably the most important thing. I don't have all the answers. You don't. None of the three of us have all the answers. It's going to be really a collective process of arriving at some sort of workable conclusion. And everybody that's involved, I think, has a professional responsibility to ensure that they're contributing in a positive way towards that resolution. But it will come one way or the other. We will find our answers. So that's just the one point that I wanted to make. Is insofar as the practicality is concerned, and substituting one role or backlogged role for another, I think that's a very relevant point at this point in time. I mean, one thing you didn't mention, and you can maybe help me, Conrad, I'm sure you know this, but you know, it's fine saying, well, let's just farm out all these matters to mediators, but let's just, so it's a few hundred matters a week are being generated through the Gauteng North and South divisions alone, never mind the other divisions in the country if they come on board. So you've got a few hundred matters a week now. How are you going to manage those matters? How's that going to, even with a full rollout of mediation? There are two problems that I see, and you know, we can drill into these problems. The first one is good quality mediators. If you're talking about several hundred matters a week, you're talking about several hundred good quality, at least good quality mediators, probably more than that, okay? The marketplace will to a certain extent take care of that. If there's a need for good mediators over time, you would imagine that they are going to emerge. But there is a little note of warning that I would sound here. And my view, and I've expressed this publicly before, is the identity and abilities and skill set of a mediator, to me, has more of an impact on a mediation than the character and identity and characteristics of a judge in a trial. For the reason that a mediator has, the mediation itself is more fluid. In other words, you have more options in a mediation. You're busy working more closely with the parties, both from a process and from a substance perspective. And the point I'm driving at is that you have to have mediators that have the right qualities, the right training, the right experience. So that's the first potential practical problem if you're looking at several hundred matters a week. The next potential practical problem, and let's say we get around that. Let's say there's a way around that through training and just market forces will bring competent mediators to the fore. The other sort of short-term challenge, and this may translate into a medium or long-term challenge, is, for instance, how does the RAF now cope with all those mediations? I understand they've got, 25 allocated as state attorneys that deal with these matters. What is the position there, Conrad? How competent is the RAF to deal with a ramping up of matters from, you know, a few a week over into mediations? Is that a real problem?
Well, let's maybe take a step back, because I believe that is the misconception that a lot of individuals have. One is not talking about several hundred a week. One needs to have cognizance that matters was placed on the roll up until 2052.
Yeah, right.
We are talking about hundreds and thousands of matters that now suddenly lost a trial date. So what is a competent attorney going to do now? He's going to say, okay, listen here, but now I need to mediate because in any event, I need my mediation certificates in order to reapply for a trial date. So you are now not talking about a couple of hundred. You are talking about a couple of 100,000. And that is not even those that were waiting trial dates. That is not those that maybe was on a default judgment trial date that was late defended and then removed and this way or this way. One doesn't even talk about the new cases that is lodged or should be lodged with the RAF. Now, if one look at a practical perspective, it's not a couple of hundred, it's a couple of 100,000. There is not enough mediators in South Africa at all in order to cope with that. Because one needs to realize those trial dates are gone. They are gone. So no attorney that I believe is now going to sit, let's say you had a trial date in 2029, is going to sit around up until, let's say, 6 months
No.
for the trial date, and then quickly jump on and do an amplified Rule 41A and start the process from there. No, he's going to act prudently and get a lot out now. And I cannot disclose this, but I have a lot that in which the Rule 41 was already delivered. 3 letters were delivered. A
Yeah.
Rule 50 was delivered. And an application to be excused from mediation was also delivered, and I'm awaiting a lot of SIC dates in order to proceed. Because one needs to realize what is the impact now, especially from the Road Accident Fund. The Road Accident Fund currently works on a model in which they work in terms of brackets, and I'm gonna be wrong if I tell the exact bracket, but just for interest sake, let's say if you go to 500,000, you need the signature of the claims handler and the senior. As soon as you go to the next bracket, you need the manager, the claims handler, the senior, and the manager to sign off. If you get, and as you work through the brackets, you need more and higher profile or higher executives to sign off on. So as soon as you get to the 5 million rand mark, you need the signature of the CEO in order to finally sign off on the settlement proposal, in order to provide that settlement proposal to the plaintiff. So this is where a massive practical implication for the RAF comes in. Because if you look at the magnitude of what the RAF is currently dealing with in terms of hundreds and thousands of matters, one can, looking at it very conservatively, if you even look at, let's say, 10,000 matters, of those hundreds and hundreds and hundreds and thousands of matters are above 5 million, needs the CEO's signature. A mediator, from what we have experienced in the very short period that we have done mediation or mandatory mediation here in Gauteng, we have noticed that mediators, they seek a full day. Even though we have indicated this is not full day worthy, we can do it in 2 hours, 3 hours, because realistically speaking, with the RAF, they need to come and provide a settlement proposal. I need to advise my client whether or not that settlement proposal is worth it. I need to advise him of his rights, and then it's in my client's hands whether or not he wants to accept that at that juncture. But now, if you look at, if a mediator wants 1 day, the CEO will only be able to sign off on 365 of those matters a day, considering that is if you say they mediate every single day. But who is then there to actually run the institution? Who is there to make sure the institution doesn't collapse? So from a practical perspective, that is what we are attempting to say, that it is not mediation that is opposed to. It is that if it is not practically workable, it is something that cannot be entertained until such time that the foundation has been laid in an institution in order to proceed with same. So that is where we are now looking at the junction. We are looking at a workload that not mediators can get to. We are looking at a workload that the RAF can't get to. We are looking at a workload that I don't believe that any department or state department can at this stage even consider.
Yeah, those are very sobering thoughts.
Yeah.
Conrad, Sheena, do you want to just respond to that?
So I think that Conrad, and I think this is really the discussion that I was hoping that we'd have, because and just to clarify, Conrad, this is RAF specific. I mean, so other mediations are, you know, commercial insurance, MVA, that kind of, they're working really well. But,
Yes.
but when you're talking about the brackets, just for our audience, that means that that the claims handler is not able to come to the mediation with a full mandate. And the directive actually requires the parties to be there with full mandate. So there's a massive disconnect there already. I think the last statistics I heard, which is probably about a month ago, that there were 190,000 backlogged RAF cases. I could be wrong about that, but if you know, and then with you shining a light on how these brackets actually work and the kind of manpower that would go into trying to get these settlements agreed to and mandated and all that kind of thing, I can see that I can see the obstacles, and I can see how frustrating it must be for litigants in and around the RAF environment. But I think we must make it crystal clear that other forms of mediation seem to be working very well, and might then be contributing to an overall alleviation of the court rolls. I know it's not enough, and I know that what are RAF matters about 80% of the court roll.
I believe it might be more. I do not have the.
I can tell you it's more than that. Sheena. It's more than 90%.
Yeah.
I just want to make a quick comment on Ian's raising the fact that, you know, mediators need a specific skill set and they need to have specific qualities, and he raises some very important points around that. And I want to highlight that the spirit of the directive is that mediators themselves should partake, and litigants should also partake in skills development for new mediators, so that we are collaboratively getting together and saying, let's have observer mediators on as many matters as possible. So again, as an RMO, we've taken that on as a developmental model, and we are asking, we're not putting pressure on parties, but we're saying we appreciate the opportunity to bring observer mediators onto any mediations where the parties are comfortable with it, without pressurizing them in any way. But so that is the developmental model, and I think it's going to work quite well over time, but it will take time to get enough skilled mediators with the kind of qualities, because many of those qualities are learned qualities. They're practiced qualities. It's like, it's an inner posture that you practice, you show up and practice every day. So yeah, but I think it's very, very important that we have this discussion about the RAF, and again, shine a light on the fact that RAF plaintiffs are some of the most vulnerable human beings in society. Many of them left with very serious injuries, some head injuries, some can never work again. And so we need to take it seriously that they can't be left out in the cold without a solution.
Yeah. Well, maybe at this juncture, I know I might seem a tad bit to an opposition of mediation, but I'm definitely not.
No, we can hear that. We can hear that.
I'm definitely pro mediation.
Yeah.
And at the end of the day, and this is maybe just, and I will touch a light on some of the RAF aspects, as it is clear to me that mediation is being chased at this stage by other litigants with extraordinary results, which I'm very glad about. And I believe that this saves a lot, not only in costs, but we as litigants understand the emotional turmoil that litigation causes to our clients and what stress it is and putting them on. And I believe that from an emotional perspective, that is saving clients. It's a saving grace to a lot of individuals. So from that standpoint, I truly support mediation as an alternative dispute resolution. However, it doesn't matter how good the mediator is if a party walks in without a settlement mandate. Because
Exactly.
even if we even go away from just the brackets, the Road Accident Fund has a merits department and a quantum department. So if merits has not been assessed by the merits department, the quantum department cannot proceed to actually look at the reports in order to make a settlement proposal. So there you bring in a totally different department. Now they have a new department that I've heard about, which is called their medical department, in which it is decided whether or not
medical unit.
which it is decided whether or not a injury is serious or not. So a claims handler cannot even consider general damages after the medical department have considered so. So it doesn't matter how good the mediator is. They are, with their current model, literally going to have to walk in with a massive team in order just to finalize one matter. So what difference? And this is the question that I asked from the very beginning. What difference is a block settlement drive? If the RAF, they came out very publicly saying that we support mediation, why do you even need to push it to mediation? Why not assess the matters and provide the plaintiffs with reasonable settlement proposals?
Yeah.
But the problem is that we, once again, the plaintiffs now currently said, and I've seen this, and a lot of stuff happens within the RAF that is very not, it's unexplainable at this stage. As there is a full bench judgment in which the RAF conceded that there is a blanket election on Section 17(4)A undertakings. But these past, if I can say it like that, 8 months, 7 to 8 months, and especially the settlement proposals that is at this stage received, does not include the Section 17(4)A. And the explanation that I got from a claims handler once was because the medical department did not qualify the plaintiff for general damages, which is something completely different. They have also decided that they don't pay his future medical expenses. And I've had instances where I literally had to go on trial just for something as simple as a Section 17(4)A undertaking. And that is phenomenal
No, that's a huge waste of resources. Listen, Conrad, I just want to, if I can just recap 1 or 2 points of the path that we've come. I think what's been very, very interesting for me this evening is the way that there's been the emerging kind of difference between other forms of litigation and RAF matters in respect of mediation. Now, you and I will know that should actually come as no surprise, because that cuts across the whole spectrum of the Uniform Rules of Court. It doesn't matter whether you're dealing with expert witnesses or you're dealing with pre-trial proceedings or whatever it is that you're dealing with. It's one what do they call it, kettle of fish if you're dealing with a non-RAF matter, and there's a whole different series of considerations, legal and practical, and just the way human interaction and all those sorts of things that come into play when you're dealing with RAF matters. So RAF matters are really a creature unto their own. And so really we should not be surprised that it seems as though this pattern is now emerging between non-RAF matters and mediation, and then RAF matters and mediation. So that's the first point. And then as a result of that, it does seem to me that because of that, and that very, very important point is that RAF matters are a very important component of litigation in South Africa because of the volume of cases. Correct. So it seems to me that when it comes to dealing with mediations, and I know the protocol already has started with this distinction between non-RAF and then specifically RAF matters. So there's recognition of those challenges. But it's the challenges relating to the RAF that seem to be emerging most clearly. And there have been many opinions, sort of very highly respected people holding the opinion that the solution to dealing with that issue is to deal with the RAF. In other words, the RAF mediation problems run to the root of what the problems are within the RAF. And unless you deal with the RAF, it doesn't matter whether you're talking about expert witnesses, mediation, or what it is, you are going to end up with all sorts of practical and juristic problems. So I would make that point as well. And then just the last sort of response is as far as costs and access is concerned, I presented at the Pretoria Attorneys Association conference a few months ago. You remember, Conrad, and someone stood up and said, even as an attorney, and I would say even as an advocate, I wonder whether I could afford the costs of full-blown litigation in this country. Now, the thing with that is that I thought that was very honest, and
that
even
was me.
Yeah, it was you. I didn't want to say, but no, I thought that, and it was absolutely the point was very well made, But the fact of the matter, and I raise it in a slightly joking way, but there's a very, very serious point there. And if we're talking about access to justice, and we're talking about the rule of law, and we're talking about the South African legal system having any real practical meaning, then we have to be able to get matters resolved within a reasonable period of time, which gets a lot of sort of airplay around the mediation process. But we also need to be efficient in what it costs to get these matters resolved. And it does seem to me that in both of those respects, mediation maps very nicely onto the South African reality. In other words, this very complicated, high-blown Victorian English juristic system, which is wonderful in many respects, but is extremely expensive and can be very lengthy. South Africa needs a sort of a pared down, simplified version, more practical, more robust, doesn't cost as much, you turn over higher volume, a little bit like that. So it's like eating at a very fancy restaurant and going to KFC. Maybe we not to do mediation disservice, but maybe we need a little bit more fast food in our resolution of this, and a bit less 3-star Michelin chefs. I'm sorry to say, but that's the reality.
But let's make it like healthy fast food.
Oh, like what? What healthy
like vegan fast food.
Do you get that?
Oh, you can
you can walk in the garden.
Sheena, that's not my field of expertise. Let's not go into my personal preferences, but that's not where I locate myself. Anyway, but I assume that there's healthy vegan fast food. Okay, and I assume that vegan food is healthy. I'll make that assumption in your favor. Okay.
Well,
anyway.
Yeah, from that perspective, I just want to unpack that a little bit, because some people might view that the mandatory perspective from mediation has now supplemented and actually made litigation costs more.
Yeah.
Because as the directive has already indicated, there is matters that cannot be mediated. So now one needs to think about, am I buying access to justice because I am forced to proceed into what all the parties know is going to be an absolutely fruitless expedition, even possibly more detrimental than it can be, because human nature is human nature. And I know this is going to be massively, people are possibly going to scream and shout at me for saying this, but that what is heard cannot be unheard, even if it is in a without prejudice basis. You will in the future, and this is what I believe, that if there is a contentious point and a party that was true towards the without prejudice nature has made certain views and certain points and certain admissions, there will be attorneys that will exploit that, not by ways of, let's say, doing it directly, but one can elude, let's say, in terms of Rule 21.2 or a Rule 35.3 and 6, and say, but remember in that mediation, he said that he has a document of, let's say, that said this.
Yeah, that's right,
let's try and get that from him, because now we have the court rules, we're litigating now. And now you're going to say under oath that you don't have it if I do it under the pretenses of a 35.3 and 6. So one cannot shy away that mediation is not all utopia, because it cannot be. Nothing is all utopia, and can be a system that can be manipulated by the clever and by the smart. So it definitely can be. We cannot think about, because if we think about a utopia, one would never think that there should be murders. One shouldn't think that there should be rapes. One shouldn't even think that there should be certain matters that needs to be. So one cannot constantly say, no, mediation is the only answer. And that's what I say, it's alternative dispute resolution. So I have, on the flip side of the coin, I believe that in certain circumstances, and that I think that's the problem that I have with the directive, is that it suddenly comes and pours a blanket over each and every matter and say, listen here, all the matters are exactly the same. Because let's be honest, is if it was not for the RAF, because most of the RAF matters, even though you deal with very integral parts of the rules and expert witness and stuff like that, if you heard 10, you maybe heard 20, you have basically, you can sit and say, okay, listen here, I have a grip on this, but just think that you have heard thousands, hundreds of thousands, then it starts becoming, and I think that the RAF and the way that they litigate has forced this directive, because I don't think that mandatory directive would have been a problem, because lead times in the court would not have been a problem. But if we want to talk about costs, let's talk about costs. The Road Accident Fund says that it comes and it stands in the shoes of the insured driver. So now, from Rule 41, the mandatory, and I say that Rule 41 was not subjected towards this, but the mandatory nature in which a plaintiff now needs to proceed with mediation, in my view, he is actually now supplementing the legal costs of the insured driver with absolutely no recourse against the insured driver. Because one has to remember, from a road accident fund perspective, is you need to prove that they lost that money. It's not just, here you go money and like a commercial settlement and go away. And you are now willing to take a little bit here and leave a little bit there, because down the road, you know that your legal fees is going to be a lot. And there's a lot of consideration in terms of this. But the mandatoriness is possibly, and I'm using this word very selectively, possibly opening up Rule 41 for constitutional challenge, in respect that it is against the Road Accident Fund Act, because the plaintiff is now, from their money, from their loss of earnings that they have proved, supplementing the insured driver's legal fees. And one thinks about it, yeah, but they are done very much quicker and stuff like that. But let's say there is a plaintiff that is proved only lost 25,000 Rand. And they need to pay, let's say, 15,000 of that to a mediator that cannot be taxed back. One cannot sit back and say, well, that's justifiable. I don't think that one can do that with a healthy conscience, because now one also needs to look at the cost implication for the taxpayer. Currently, the special default judgment dates are in August 2026. That's for matters that was removed in October and November. That should have proceeded and been finalized on the civil trial roll. Now they were bumped to a special default judgment roll. And as I said, it's a little bit strange, because now you need to follow two processes. It could have been done in October, November, but now a new process needs to be followed in terms of the uniform rules of court, because it's a default judgment. There's more legal fees, and it's pushed down the road, and that's going to have an impact on the taxpayer. So legal fees are going to get more, and that is the problem.
No, I think, there are a number. Look, this initiative will have all sorts of detailed repercussions, and we'll have to fine tune the system and what have you. I think we're at the point where I think probably the most important point that's emerged from this evening's discussion is, if one separates the concept of mediation from the process of how we implement mediation and roll it out in this country, I think that already takes you a step forward. So let's divorce those two concepts. And a lot of the criticism and kickback and what have you has been about concerns about how the process has been rolled out. I would also again make the point that previously Rule 41A also failed, or that did fail. So we have to get an improved rollout. It makes sense. I must tell you, my natural instinct, I have to say, is to always tend towards education. Okay, so my natural instinct when I look at a problem like this is my view is that probably your best result is going to become, it will come through discussions like this, education and understanding exactly what it is that mediation has to offer, what are the challenges, and the more informed we can be about the concept of mediation and how we roll it out, the better the solution will be and the more productive your collaborative effort will be. That's on the upside. And so a conversation like this to me is very, very important. There's some difficult concepts locked up in here, and there are other concepts we didn't go into, things that are before the court, etc., which will be ventilated by the court system and more broadly through civil society. But I would just my last thought on this is that as I say, to separate the concept of mediation from the process, and then I would encourage to find out professionally as much as you can what the options are for your clients, and then to stay abreast of what these developments are. And as individual practitioners through your organizations, I mean, you're remember a number of very prominent organizations, Conrad, and they do phenomenal work in representing your profession. And every sector of society must then do that. That is civil society operating properly. But I found this a very, very interesting conversation indeed. I mean, I have a personal injury practice myself, so and I find what's happening up in Gauteng very interesting. Sheena, any thoughts from your side?
Yeah, I think it's such an important discussion, and I'm so grateful to Conrad for coming and having this discussion with us. And I think, as we've said before, there's a flexibility built into the directive. So it's going to take all of us to figure this out together. So, if we can keep our minds open and our hearts open to solve the problem and say, let's try to see together where the answers lie. But I think that just knowing some of the obstacles, I mean, the stuff that Conrad has ventilated tonight that I had no idea about, and it's I hope my mediators are going to watch this discussion, because I think it's we all need a bit of a reality check on it's exactly that. It's not just all going to be rainbows and fairy tales and utopia and that kind of thing. It's going to be messy, and but we're all wanting to work towards the same goal, which is to increase access to justice for all South Africans. Yes. And so I do believe that mediation is a good platform for that. It's an accessible platform. But we have to be realistic about the problems that exist within the RAF and figure that out altogether, how to address that.
Yes.
Conrad, just before your final thoughts, I just really want to thank you for coming onto the program. It's such a valuable, absolutely valuable insight that you give. As I say, from the coalface, these are the real challenges. It's fine talking about mediation in theory, it's fine looking at the theory of it, and you even look overseas at how it works very, very well, for instance, in the UK in clinical negligence matters, but they don't have a creature like the RAF. And just to hear your insights generally and specifically with regards to the RAF, I think is a phenomenal contribution to the discussion and to the thought process that's taking place around this topic. But Conrad, let's maybe just get your concluding remarks then as we head towards the end of our time.
Yeah, well, I just want to say thank you, and thank you for having this opportunity to ventilate. It's very rare that one has the opportunity to sit and ventilate certain issues. And I know that my mind, regarding from what was said by you, yourself, Ian, and also Sheena, is definitely looking towards rather attempting to create and or go towards a workable solution that we are sitting with, instead of actually attempting to, let's say, constantly fight the system and not be open for change. So thank you for that, and thank you for the opportunity to actually sit and ventilate certain of the issues. I think if we need to sit and ventilate all the issues like the Minister of Police and stuff like that, we're going to be here the entire night. But
Oh,
we
yeah.
definitely have the viewers stay tuned for what is there, because I don't believe that we have even scraped the surface of what is needed to be talked about. Because if we're going to talk about the issues and we address it head on, we can then only find a solution. But if we don't address it head on, and we just make like a ostrich and just put your head into a hole and think that nobody can see your body, we are actually heading towards a disaster in terms of what we thought we want to achieve. And that is definitely, I don't think anybody's goal, but the realistic thing if we do not act and we do not find solutions.
No, definitely. Indeed.
Thank you so much.
Thank you,
Sheena,
guys.
you just want to make some concluding remarks then? Yeah, I've found this absolutely fascinating. Very, very good discussion. I'll send you a copy of the Quantum Guidelines, Conrad, his book that we've just brought out, which is basically, well, let me give it a little bit of a plug since Sheena's opened it. It's a look at quantifying personal injury claims. So it has the traditional sort of list of cases, but there are a couple of features in the Quantum Guidelines that there's nothing in South Africa that deals with this. Like number one, we summarize the key principles of quantifying damages. Number two, we look at the narrative test, which I was very interested to hear you talk about that medical unit within the RAF. Absolutely, that's the narrative test, the assessment of the seriousness of an injury. And there's a chapter devoted to that on the narrative test. And then another very important feature of this book, which I don't think appears in any other work, is when a diagnosis is made, the important difference between an injury diagnosis and an outcome diagnosis, and how a proper assessment should include both of those two diagnoses. And incidentally, this is my particular point, I say injury diagnosis goes into the merits or liability, and outcome diagnosis is relevant to the quantification of the claim.
Yeah.
Anyway,
Very,
so I
very
will happily send you a copy. I will
And
inscribe
then,
it.
and then, Ian, we need to discuss that bundle for my mediators as well, just so that
Let's get that there.
they know that I'm looking out for them too. So yeah, we'll have that discussion.
Fantastic.
But yeah,
Thanks, Sheena,
amazing discussion, and I hope we can get Conrad back sometime. I think there's lots more to explore. So Conrad, expect a call.
Thank you guys so much. I really appreciate it.
Thanks, Conrad. Very nice seeing you again. Nice seeing you, Sheena. Cheers then.
You too.
Cheers, everybody.
Cheers.
Bye-bye.
Bye.
Bye.